Picture this. You run a company, you hire the lawyers, you approve the settlements, you can fire anyone in the building on any given day. And then one morning, you walk into your own office, sit across from your own staff, and file a lawsuit demanding that company pay you $10 billion. That's not a hypothetical. That's what's happening right now inside the United States federal government. And the number that makes this story genuinely difficult to wrap your head around, $10,000, $10 billion, that's billion with a B, from the IRS alone. On top of that, there's a separate claim for $230 million sitting at the Department of Justice, a department staffed at its most senior levels by people who used to be Trump's personal defense attorneys. The sitting president of the United States is, in the most literal legal sense, attempting to extract billions in taxpayer money from a government he controls, and the people responsible for deciding whether to pay him work for him. Not metaphorically, literally. Let me walk you through exactly how this happened, why it's legally unprecedented, and why a conservative former Supreme Court clerk is using the word outrageous. Start with the IRS lawsuit, because the details are almost impossible to believe. In January 2026, last month, Trump filed suit in federal district court in Miami against the IRS and the Treasury Department. The claim that a contractor named Charles Littlejohn stole and leaked Trump's tax returns between 2019 and 2020, causing him lasting reputational and financial harm. He's seeking at least $10 billion in damages. Littlejohn is real. The leak was real. He pleaded guilty in 2023 and is currently serving a 5-year prison sentence. This is not a fabricated grievance. Now, here's where it gets complicated. The leak happened in 2019 and 2020. At that time, the IRS was run by Charles Rettig, Trump's own nominee. The Treasury Department was run by Steven Mnuchin, Trump's own cabinet secretary. Trump is suing the government for a security failure that happened on his own watch, under his own people, during his own first term. Read that again. Read. He is suing the government for his administration's failure to prevent a contractor from leaking his records. The contractor who leaked them is already in prison. The agencies that failed to stop him were run by Trump's hand-picked appointees, and Trump is now asking taxpayers to pay him $10 billion for it, filed as a lawsuit in the district court closest to Mar-a-Lago, presided over by a federal judge appointed by Barack Obama, while he is simultaneously the head of the executive branch that will decide whether to fight him or settle. Tax law experts quoted in reporting this week note at least two major structural problems with the suit. First, the statute of limitations may have already expired. The events occurred in 2019 and 2020, and the legal clock for these kinds of claims is not indefinitely open. Second, punitive damages, a significant portion of what Trump is seeking, are generally not allowed under the Federal Tort Claims Act, the law being used as the basis for both this case and the DOJ claims. There are narrow exceptions. Legal analysts say Trump's situation doesn't fit them. So why file a case with those structural flaws? That's the question worth sitting with. Is this a serious legal claim, a political statement, or something else entirely? I've been thinking about that one for a few days, and I'd genuinely like to hear your read. Drop it in the comments. Now layer in the DOJ situation, because that's where this gets constitutionally strange. Before he won the 2024 election, Trump filed two separate administrative claims with the Justice Department, a required first step before you can formally sue a federal agency. Together, they seek $230 million. Claim 1, damages for the Russia investigation. The special counsel probe examined whether Trump's 2016 campaign coordinated with Russian interference in the election. No charges were ever brought against Trump personally. He wants $115 million for having been investigated. Claim 2, damages for the Mar-a-Lago search. In 2022, the FBI executed a court-approved search warrant at Trump's Florida estate, and recovered classified documents from a bathroom, a ballroom, and an office. The subsequent criminal case was dropped when Trump won the presidency. A sitting president cannot be federally prosecuted. He wants another $115 million for that. Now, here is the constitutional tangle. Under Justice Department policy, any proposed settlement above $4 million must be approved by the Deputy Attorney General. The current Deputy Attorney General is Todd Blanche. Before this role, Blanche was Trump's personal defense attorney in the classified documents case, the very case that generated one of the two claims Trump is now pursuing for money. The Attorney General herself, Pam Bondi, also previously worked as a Trump defense lawyer. The third-ranking official at Justice Stanley Woodward represented Trump's valet, who was charged as an alleged co-conspirator in that same classified documents investigation. So the institutional structure looks like this. Trump files a claim. The claim is reviewed by a department he controls. The officials authorized to approve a settlement used to work for him personally. He is, in the framing of one legal ethics professor, both the plaintiff and the supervisor of the defendant. This is where the language starts to escalate. Edward Whelan is a former DOJ lawyer and a political conservative, a man who clerked for the late Justice Antonin Scalia, not someone you'd normally expect to be quoted alongside Democratic senators. He called the situation outrageous and said it is outrageous that Trump and those answering to him would be deciding how the government responds to these extravagant claims. That's not a Democratic talking point. That's a conservative legal scholar who worked in the building describing what's happening as outrageous. Here's the part most coverage is burying underneath the ethics arguments. Strip away the legal framework and the institutional conflict of interest, and you're left with one concrete question. Where does this money come from, and what does it cost? The $10 billion IRS lawsuit represents roughly two-thirds of the IRS's entire annual operating budget for 2026, which is $15.2 billion. The agency that Trump is suing is simultaneously being staffed down. Thousands of IRS workers have been cut or resigned in the past year, and a National Taxpayer Advocate report warned this week that the IRS is entering filing season with diminished capacity to help the 140 million Americans filing their taxes right now. $10 billion, if paid, would roughly double Trump's estimated net worth. That's not a rhetorical flourish. That's a calculation from Citizens for Responsibility and Ethics in Washington, a watchdog group that filed legal arguments this week asking the court to consider blocking any settlement while Trump remains in office. For context, the $230 million DOJ claim alone, before we even get to the $10 billion, already exceeds what the entire Justice Department paid out in settlements for all other claims in 2025 combined. It dwarfs the $138 million settlement with victims of USA Gymnastics abuser Larry Nassar. It's larger than the $88 million paid to the families killed in the Mother Emanuel Church shooting. That's the company this number keeps. $10 billion is what the Trump administration tried to cut from the National Institutes of Health medical research budget, cuts to cancer research, diabetes research, cardiovascular work, before courts intervened. The $10 billion would fund the Consumer Financial Protection Bureau, which the administration gutted for its entire existence twice over. The CFPB recovered $26 billion for American consumers since 2011. Trump's claim against the IRS is more than that recovery. These are choices, and they're choices being made by people who answer to the plaintiff, the ethical escape hatch being offered, and why it doesn't quite close the door. Trump, when pressed by NBC's Tom Lamas about whether it's appropriate for taxpayers to foot this bill, offered an answer that became immediately infamous in legal circles. He said he'd tell them to pay him, but he'd give 100% of the money to charity. Let's take that at face value for a moment. Setting aside the documented history of charitable commitments from the Trump Foundation, which was dissolved by a New York court in 2019 after a ruling that found it had been used to benefit Trump's political campaign and personal interests. There are still two legal problems with the charity framing. First, directing billions in congressionally appropriated funds to charitable organizations. Those funds were never appropriated for presents, its own constitutional questions around executive spending authority. Second, a legal donation of that size would itself generate a massive tax deduction for Trump. So even if the money went to charity, he would still derive a personal financial benefit from the government payout. Democrats have already introduced the Prevent Presidential Profiteering Act, a bill that would impose a 100% tax on any civil judgment or settlement paid by the U.S. government to a sitting president who filed the legal action while in office. The bill passed no further than its announcement. The Republican-controlled House has no appetite for it, but its introduction signals where the political pressure is building. Watchdog groups, Common Cause and the Project on Government Oversight among them, filed a 23-page friend of the court brief this week asking the Miami judge to delay the IRS case until Trump leaves office in January 2029. Their argument is specific. The structural conflict of interest is so severe that the government cannot be counted on to defend the public treasury with the same vigor it would bring against any other plaintiff. This creates the risk of the most collusive lawsuit of all time, one ethics expert told the Senate Finance Committee, because it is ultimately the president suing a defendant whom he says has to do whatever he directs. And here is the thing that nobody in either party seems comfortable saying plainly. Trump himself said it at a rally in December, doing his impression of a news anchor's voice. Donald Trump sues the United States of America. Donald Trump becomes president, and now Donald Trump has to settle the suit. He acknowledged the absurdity. He found it entertaining. He said, "I negotiate with myself." That line, "I negotiate with myself," Yin is doing a lot of work. It's simultaneously a joke and a confession of the exact conflict of interest that legal ethicists are alarmed about. And it was said at a campaign-style rally in front of thousands of people, which means it wasn't a slip, it was a performance. Which brings you to the real question underneath all of this. Is this a serious legal claim? Probably not entirely. The statute of limitations problems, the punitive damages restrictions, the structural flaws are real. Is it a form of political communication? Almost certainly. Trump has used litigation as a messaging tool for decades, win or lose. Is it an attempt to actually extract money from the government? Possibly. Is it a test of how far his appointees will go to serve him personally? That might be the most honest reading, because here's what actually needs to happen for this to resolve. The Justice Department has to decide whether to fight these claims or offer a settlement. Bondi has to approve anything above $4 million. Blanche has to sign off. Both of them are former Trump attorneys. If they recommend a settlement, even a fraction of what's being sought, it goes to the president for his approval. He said himself, he's negotiating with himself. The judge assigned to the IRS case in Miami has discretion. She could dismiss it. She could delay it. She could require the parties to produce documents showing how the settlement deliberations are being conducted inside DOJ. Any of those routes could take years. But the clock is running, and there is no institutional mechanism that automatically prevents this from resulting in a payout. The safeguards that exist assume the parties are genuinely adversarial. In this situation, they are not. A sitting president is seeking a personal financial windfall from a government he controls through a process supervised by his former defense attorneys at a moment when the same administration has been cutting spending on cancer research, consumer protection, and the very tax agency being sued. The legal term for this kind of situation, where the structure of a claim makes genuine adversarial review impossible, is a collusive lawsuit. Courts take them seriously. Whether this one gets the scrutiny it warrants from the institution that would have to provide it is, at this point, genuinely uncertain. And that uncertainty is the story. Here's what I keep coming back to. Is there any version of this that ends without either a payout or a constitutional crisis? Because I'm struggling to find the clean exit. Tell me what you're seeing that I might be missing. Your read in the comments.